Hey there, Sean Stewart at Stewart & Co. Real Estate. We are at St. Peter House today, a 7,000 square foot standalone villa overlooking the wonderful west coast of Barbados. I'm going to be speaking to Erica Marshall-Forde, partner and head of real estate at Dentons Delaney. She's going to take us through things that buyers, both local and foreign, want to watch out for, should be aware of, and just to make life easier as you go through the purchase or sale transaction. Without further ado, let's get to it.
Erica, thanks for joining me. Before we dive into the legal side of things, tell me a little bit about your role and your work in the Caribbean.
Sure. I am the head of property at Dentons Delaney, and what that means is for the 13 jurisdictions throughout the English-speaking Caribbean that Dentons Delaney covers, whether you are a developer, or a purchaser, a seller, or an investor in property in the Caribbean, those transactions are handled by my team.
Amazing. And what do you most enjoy about your role?
So property is a dream for a lot of people. And I think in my role, I get to see those dreams come alive. Developers who have a concept in mind and working alongside them, whether it be engaging them with the different planning laws,
Yep.
or just property laws in general that will affect what is being sold, and helping them to build that dream into something that is then sold.
Yeah.
And likewise, working for purchasers who also have a dream of owning a property in the Caribbean, whether they're from the Caribbean or whether they are non-resident and looking to invest in the Caribbean.
Yeah.
Working alongside them and bringing those dreams to fruition.
Seeing the whole thing through.
Yeah, that's definitely the most enjoyable part for me.
Let's start with some basics. What are the key legal steps that a buyer would go through when buying property here?
So before we actually get to the legal step, they engage with you and negotiate their offer.
Yep.
That offer is accepted, and then it's turned into an offer and acceptance, which is then the document that is presented to the vendor or the seller's attorney.
Right.
And they use that to turn it into an agreement for sale, a sale agreement, or a sale and purchase agreement as it's known in some parts. So that's then the first step in the process, the draft sale and purchase agreement, which is prepared by the vendor's attorney and sent to the purchaser's attorney for review. As purchaser's attorney, we review the agreement, make sure all is in order, of course, have a discussion with our client about it, make sure their interests are properly covered. And once the agreement is settled, it's finalized and sent to the purchaser for signature. And at that point in time, they pay a deposit. So when the agreement is signed and the deposit is paid by the purchaser, it then goes back to the seller's attorney or the vendor's attorney.
Right.
The vendor then signs, and it's at that point that we say we've got exchange of contracts.
Right.
And you have a binding agreement then, and the process continues from there.
Until completion.
After the agreement is signed, then you have your due diligence, where the purchaser's attorney is investigating title, making sure that all is good and that there is good and marketable title to be sold to their client. And once that due diligence process then is completed and everything is found to be in order, we move to the third step, which is essentially preparations for completion. That's when the transaction documents that are going to indicate that the purchaser is now owner of the property.
Right.
When those documents are then finalized and settled, and you have the exchange of funds for title deeds or transfer documents.
Understood.
And title or ownership is passed then from vendor to purchaser. And that's essentially the transaction in a nutshell. Of course, there's a lot more intricacies to it
that happen in between.
Yes.
Yeah, absolutely. And one of the frustrations that I've been made aware of obviously from foreign buyers, especially because they're not used to it, is the amount of time that it can take, not knowing what has to be done and how it all works. Obviously, our system here is different, probably not as evolved as other systems in the world. So what would you say is a reasonable expectation of time for a transaction to take place?
So we would usually advise between 60 to 90 days.
Okay.
And the reason for that is because in Barbados, we predominantly deal in with unregistered title. And what that means is that your ownership to a property is traced through physical title deeds. So a stack of title deeds going back 20 years, which showed that in 1990, Sean Stewart owned this property and he transferred it to Erica Marshall-Forde, and she then transferred it to someone else, and so on and so forth, up to the current point. And so because that's the way that title is traced for unregistered property, then that also takes up part of the process, because we're charged with making sure that title to the property is good. So the property searches are a bit more involved and comprehensive than it would be for registered title, where it's simply enough just to look at the title register and see all of those things that we would otherwise, for unregistered title, have to flip through title deeds to look at. So that's a big part of the process. The other part of the process that tends to take a bit of time is having various clearances that you may need in order to transfer that good and marketable title.
Okay.
So land taxes, for example, those have to be paid up to date. And in Barbados, one of the requirements is that you're producing a land tax certificate. So if it's a case where there's an issue with land taxes, then that could draw out the process, because it means that vendor is trying to settle that issue in the background before their attorney can be provided with the current land tax bill and land tax certificate. And again, that's something that could stretch out. So whilst the 60 to 90 days might seem to be a while, and I acknowledge that it would be a while for persons who are used to doing transactions in 30 days based on the system that is prevailing in their home jurisdiction, there are those factors that come into play that draw out the transactions here, and that's why that timeline that I mentioned would be realistic.
Fair enough.
And I'm assuming based on that, and this would naturally apply to anything, but the more prepared the seller and the purchaser, for that matter, are, the more likely the transaction is to adhere to the timeframes that you may outline.
Most definitely.
Right.
So I did mention that 60 to 90 days. Transactions can be done in less.
Right.
And one of the things we tell sellers who are coming to us is, let's make sure that everything is in order from the time that property goes on the market. Because once we are able to ensure that all of those boxes are ticked, it ensures a seamless transaction. And you can very well have a completion timeline that is less than 60 days. And we've done it before.
Yeah, makes sense.
And how early should a buyer involve a lawyer in the process?
So from the time you're serious about the property and you're making an offer, I'd say that's the point that you should start speaking to an attorney. And the reason for that is there may be questions that you've got about the property. Of course, your real estate agent can answer them, but sometimes they're bordering between a transactional and a legal nature.
Okay.
And it might be useful to have that feedback during the initial stages.
Right. Understood. What's one common misconception that non-residents have about buying in Barbados?
So one of the most popular ones is the thought that a survey of the property is part of the process. And when I say survey of the property, I'm not speaking of survey of the boundaries to the property, because that is part of the process, but more so a survey on the actual building and structure itself.
Condition, etc.
Yes.
Okay.
So because in a lot of markets, that is something that they're used to, and that is something that is part of the process, it's a natural question that arises here: when should I have the survey conducted? And we would indicate, well, the survey is not a requirement for purchasing property in Barbados. It's definitely not something that wouldn't be recommended, But because it's not a requirement, then it's something that the buyer or the purchaser covers the cost of. And we would recommend that you do it as early as possible, again, to ensure that you keep within that optimal timeline for the purchase. And one of the things that purchasers could also consider is making their offer conditional on the outcome of that condition assessment or condition survey.
Very interesting, because yes, having worked in the UK property market and now being here, a survey means two completely different things. So it's interesting to hear that coming from you, what the expectation is when someone mentions the word survey. So just moving on a bit, are there any restrictions on foreign ownership in Barbados?
No restrictions on foreign ownership, and that's one of the things that makes Barbados appealing to a lot of purchasers. So in some of the other jurisdictions, you might have a requirement for a landholding license.
Okay.
Or if there's citizenship by investment, there are certain factors that have to be satisfied.
Okay.
In Barbados, the only requirement for a non-resident purchaser is that they're required to get exchange control approval from the Central Bank of Barbados.
Right.
And what that means is your funds for the purchase have to be registered with the central bank, and the central bank confirms that those funds have been registered. And once those funds have been registered, i.e. you have invested foreign currency in Barbados to purchase your property, then they issue what is known as a TR form, which allows for the transfer of property to a non-resident
Understood.
purchaser. It also works similarly if the purchaser is resident and the seller or the vendor is non-resident, in that you would require that central bank approval.
Right. Okay.
And just to explain the registration process a bit more, it is very simple. It is something that the buyer's attorney would do on their behalf. They're going to send in funds to purchase the property. It's going to come to the attorney's client trust account. The attorney gets a credit advice from their bank that shows that these funds have come in, that they came in foreign currency, and that they're being used to purchase the property at XYZ location. They say to central bank, this is the contract between the buyer and the seller, and these are the funds that have come in to purchase the property. Please, would you register these funds?
Right.
Please, can you issue the form that shows that these funds have come in and you know and have approved that these funds are being used for that purchase?
Right. Understood. Okay. Makes perfect sense to me. Could you explain the importance of title searches and what's involved?
Sure. So earlier on, I mentioned our obligation to ensure that there is good and marketable title.
Yep.
And when we're speaking about good title, we want to ensure that there are no charges against the property or no encumbrances against the property.
Okay.
That the property is not burdened with anything, any third-party interest that would prevent me buying from you, and in that process inheriting ownership that's fully and solely mine.
Right.
Obviously, if there's a third-party interest or something bearing on the land, it's going to affect how I am able to own the land.
Of course.
So the reason we conduct those title searches is to identify whether there are any charges, whether there are any encumbrances, whether there are any third-party interest that have to be relinquished.
Right. Okay.
For you to fully pass title or ownership to me.
Interesting.
So one example of that, for instance, might be a mortgage. A lot of persons may have gotten financing when they purchased the property. They're now coming to sell. They may have paid off the mortgage, or they may be using part of the purchase proceeds to settle the mortgage facility. One of the things that our title searches would show is that there's a charge against the property, and that charge is registered in the name of a particular financial institution. We then know that in order for the title to be passed, a release of that mortgage has to be a part of the title bundle that is being handed over to us at completion. So it helps us to identify any relinquishment of rights or charges that have to be handed over when title is passed.
Understood. What are some red flags that might pop up during the legal review of a property?
I'll speak to three of the most I wouldn't want to say popular, but,
right? The ones you see most often.
Yes.
Yeah.
So one of the first things is the title deeds and where they are. So we often ask vendors when we're working for them, where are your original title deeds? As I mentioned to you earlier, most of the title in Barbados is unregistered. Right. So it's that original stack of deeds that has to be handed over as part of your good title. If you don't know where those deeds are, then that could potentially be a problem.
So this is interesting because I, having heard this before, it's amazing. The owner could have these deeds anywhere.
That's right.
They could get lost. They could get wet. They could get burnt. They could get blown away. Mm-hmm. It's a pretty important document to leave to chance, so to speak.
Yes. It doesn't happen every day, but there are times that, property may have changed hands, you may have moved, and for some reason you can't track down the title deeds. They're either lost or misplaced.
Wow.
And what that means is that those title deeds then have to be restored. And the restoration process means we go to the land registry and ask that the copy that the land registry has be certified as good as the original.
Right.
It's simple in terms of what it is, but there is a process associated with it. And that could take anywhere between 6 to 8 to 9 months.
Wow.
And so therefore it's something that you want to know before you actually sell the property. So the earlier you know it, the better, so that you know what timeline you're dealing with, and you know that the restoration process has to be started as soon as possible. So that's one of the red flags that we see.
So I guess advice to a seller is don't keep the title deeds under your bed or
definitely not
fold it in your pocket or something like that.
So keep them in a safe place.
Yeah.
Some purchasers on buying a property feel comfortable leaving them with their attorney to keep in a safe place.
Right.
And that's perfectly acceptable. That's something that can be agreed between you and your attorney. If that's not something you feel comfortable with and you want to have those deeds tangibly with you, then please keep them in a very safe place.
And if the property is purchased with a mortgage, does the bank hold on to those title deeds until such time as the mortgage is paid off and relinquished?
That's right.
Right.
So the bank, because it has a charge over the property, is going to hold those title deeds until you pay the facility in full. And the release that I mentioned earlier on up in our conversation, once that is signed by the bank, they would hand over the title deeds with the release back to the owner.
Okay. Were there a couple of other ones that you were going to mention?
Yes.
Yeah.
So the second flag or potential issue is if there's an estate involved in the sale and purchase process.
Right.
So you may have owned a property, passed away, and either died with or without a will. And in either circumstance, your estate has to be dealt with before the property that you own can be sold. So that's something, if it hasn't been done before a property goes on the market or an offer and acceptance has been signed, if it's going to be dealt with during the currency of the sale and purchase process, it's going to stretch it out.
Is this something that you would then recommend to a seller, or an agent recommend to a seller prior to putting the property onto the market, that the estate is sorted, rather than having it come up in the middle of a transaction?
Most definitely.
Right.
Yes. So, but the unfortunate thing is that some people don't know, and they might unknowingly, in having the conversation with their estate agent, say, well, yes, everything is in order, and yeah, my mother owned the property, and I'm now able to sell because she would have left it to me anyway.
Sure.
Not having gone through the actual process in order to be able to sell the property.
But if I hear that statement as an agent, really I should be saying, has the estate been sorted out?
Exactly.
That should be my next question.
Exactly.
Right. Okay.
Exactly. And one of the other potential flags is if there are any encroachments on the property being sold.
Okay.
And what you're talking about when you speak of encroachments is that boundary survey that I mentioned earlier. Obviously, the property's got certain boundaries. It abuts and abounds on places in the north, south, east, and west.
Yep.
And it measures certain dimensions. If something on my property is protruding onto your property, that is potentially an encroachment. There's something not belonging to your property that is on your property, and it's affecting the boundaries to your property.
Right.
And that's something that you definitely want to have dealt with, because what it means is when the purchaser is buying, they could potentially be buying a property with something on it that ought not to be there. So you want to have either the encroachment removed or some meeting of the minds between the person that's encroaching and the property that is being encroached on as to removal in the future.
That's an interesting one. And I'm always intrigued by that, because there are then lots of spinning wheels happening all at the same time.
Yeah.
Interesting. Could you take me through some of the typical costs involved, like stamp duties, government fees, transfer tax, etc.?
So you've got your property transfer tax and stamp duty. The property transfer tax runs about 2.5% of the purchase price.
Okay.
If there is a structure on the property, there is an allowance that's deducted from that 2.5%. The stamp duty runs 1% of the sale price of the property. These costs are borne by the seller or the vendor, so they're not buyer's cost.
Okay.
The buyer's cost would be any amounts that are spent on title searches, because that's usually an out-of-pocket expense, and recording the transfer documents, whether it be a conveyance at the land registry or a sure transfer document with the registered agent or with the corporate affairs registry. Those costs are based usually on the value of the property being transferred.
Understood. Okay. Some purchasers will purchase via a trust or a company. What's the legal basis behind doing so? What are the advantages or disadvantages of doing this?
So it's all about structuring your affairs. And the benefit of purchasing in a trust or having a trust as part of your structure is that it allows for easy management of your estate on your death. You don't have to worry about your will being probated or your estate, quote unquote, being settled before you're able to sell this. The trust has inbuilt factors that deal with how the property is supposed to pass. You might also own in a corporate structure, and the benefit of that is really on resale of the property. It helps you to avoid, and legally so, those taxes that would otherwise be payable by you as seller, that 3.5%. And I'll stick a pin there to say that would be legitimately avoided when you're talking about sale of shares in an offshore holding structure.
Okay.
And not a domestic or local structure, because those would still come under our property transfer tax and stamp duty laws, and therefore that 3.5 would be applicable.
Right.
Whereas if you're selling the shares in an offshore property, let's say, for example, you've set up a company in the BVI and then registered it here in Barbados so it could own property, you're selling the shares in that BVI company, and therefore, because it's an offshore transaction, our property transfer tax and stamp duty laws wouldn't come into play, and it saves the seller then that 3.5%. So those are the reasons that persons might want to consider a trust structure or a corporate structure. Of course, we also tell buyers to ensure that they get tax advice from their resident jurisdiction, because that might also have an impact on whether they would employ a structure to own the property, or whether it might be more beneficial for them just to own it in their own names.
Very interesting. And I think it's something that is not always considered. A lot of the time, the consideration on the purchaser's part until they're advised otherwise is, how does it affect me tax-wise here in Barbados? Without thinking, actually, how does it affect me back at home where I actually pay tax?
Yes.
Interesting. And it's wise to understand that each individual and their situation is going to dictate what's best as far as the purchase is concerned. There's no one general rule for any particular demographic, any particular type of buyer. It really does come down to what the purchaser wants to do long term and what their current situation is both at home and here in Barbados. Is that right?
That's absolutely right, Sean.
So I just want to talk a little bit about purchasing a condo versus land versus a house. Are there any legal differences between purchasing a condo, standalone home, or just land?
So the legal differences, and it's mostly between a condo and the standalone land and villa. We can put those in one category together.
Okay.
So when you're purchasing a condominium, what you're purchasing is the actual unit as well as a share in the condominium property, or a share in the common property of the condominium. So the condominium is a building, obviously, and there are going to be spaces that are not owned by any one person in particular. They're shared spaces.
Corridors, etc.
Corridors, stairways, there might be a garden, and those are owned by all of the condominium unit owners. And so because you're a condominium unit owner, you've got a share in that common property. So it's your flat or apartment, if you will, plus that share in the common property.
Understood. For buyers considering off-plan or pre-construction purchases, what legal protections should they ensure are in place?
One of the key things that they want to make sure, even before they enter into the contract, is that the developer's got the requisite approvals to build.
Okay.
Because you don't want to be handing over your money and then somewhere during the process you realize that there's something not just right with those approvals that have to be made.
How would one go about doing that?
So in having the conversation with the developer or with the developer through your agent, you just want to make sure that the relevant approvals are in place.
And that should be relatively easily forthcoming.
Exactly. Right. The other thing you want to make sure is that there's some protection for you if the project goes over time and goes over time by a significant number of months, for instance. Because obviously you've made this investment and you've made this investment expecting that you are going to be able to start generating returns from a certain time. It's going to have an impact on you if it's not finished by that time or shortly after, and you don't have proper notice and time to agree with the developer that you will allow for an extension. So the protection that you would want to have in the agreement in those instances, that is where you've not agreed with the developer that there's need for an extension, would be liquidated damages. That's where there's a dollar amount assigned to every day or week that the property is not handed over, or is not in a position to be handed over to you. So you kind of recoup some of those losses that you might have incurred.
Okay, interesting. If you could give advice to someone buying for the first time in Barbados, what would it be?
Know the property that you're buying. And by that, I mean, ask as much questions as possible. There's no question that is too insignificant to ask. You're purchasing in Barbados for the first time. It's a system that you're not familiar with. You may think that you know because you've purchased properties in various parts of the world, but there are different systems in different parts of the world. And even where there are similarities, there could be some small differences. So ask about the process, ask about the property, how long it's been there, whether there are any issues with planning in relation to the property. You want to know that the property is structurally sound if it's been there for a while. And that's where the survey that we mentioned earlier comes into play. You want to know whether there are any issues on the seller's side that might prevent for a smooth transaction. So like whether there's an estate involved, or whether it's owned by a holding company, and if that holding company is in good standing. whether there are any taxes owed on the property. Ask as much questions as you think of so that you can know the property that you're buying, so that there are no surprises when the process starts.
Yeah, makes sense. Stitch in time saves 9.
Exactly.
And for those who've already bought or bought a while ago and they haven't looked at their structure or agreement for a long time, should they revisit?
Absolutely, because there are changes to the laws ever so often. I won't say every day, but ever so often. And they could have implications for you today that they wouldn't have 10 years ago when you bought.
Right.
So, for example, if you bought a property 10, 20 years ago and owned it in an offshore holding structure, depending on that, the jurisdiction that the company was incorporated in, there may have been changes that require you to make additional regulatory filings, and you may not be aware of those.
Right.
Your corporate service provider would be able to advise you of those changes, and presumably should be advising you on an annual basis what requirements there are.
Yes.
But you also want to be familiar with the requirements, and if they're becoming too onerous, and if you need to consider a change in the structure.
Yeah.
You may not have had children 10 years ago when you bought the property, and you now have children. You might want to consider putting a trust in place and having that trust somehow incorporated into the ownership of the property, so that it makes managing your estate a lot easier.
Interesting. Yeah, it makes sense. A lot can change in 5-10 years. Where can people reach out to you or the Dentons team if they want to get some legal advice?
So finding us is pretty easy. You go to dentons.com, and
that's easy.
It takes you to the different jurisdictions that Dentons globally covers. Obviously, you can find the Barbados team in Barbados. Me personally, I'm erica.marshall-forde@dentons.com.
Perfect.
But like I say, if you go to the website, we are very easy to find.
I'm going to shoot a few questions at you. They're quick questions, and I think they're good, digestible bits of information that people may find helpful.
Sure.
Do foreigners need a special permit or license to buy? Myth or fact?
Well, that depends on where you're buying. But if you're talking about Barbados, if you're talking about Barbados, then that's a myth.
Do you always need to fly to Barbados to complete a transaction?
That's a myth.
It's a myth.
You may want to, and that's absolutely permissible, but you don't have to be there. The closing is a meeting between the attorneys where funds or completion funds are exchanged for ownership documents.
Okay. Is buying a beachfront property in Barbados more complicated than any other?
Once you've got a capable attorney, absolutely not.
I like that. Excellent. Erica, I think I've grilled you enough in one session. Thank you so much for your time. It's always a pleasure. And I look forward to chatting to you again soon.
It was my pleasure as well, Sean.
Thank you.